Welcome to the Epilepsy Foundation of Connecticut webinar series. This is Monica Anzalone, and I'll be moderating the webinar for today. For the purposes of sound quality, we have put everyone in the listen-only mode, but we do welcome you to use the chat icon on the bottom of your screen to type any questions. All of the questions will be answered at the end of the presentation. Today's topic is for both the job seeker and the employed. We have found here at the foundation that many people are not aware of their rights in the workplace, and this includes disclosing their disability and accessing a reasonable accommodation if needed. We have asked a lawyer from the Greater Hartford Legal Aid to join us today to discuss these areas of concern. Amy Corbett Dion is a staff attorney at the Greater Hartford Legal Aid. She divides her practice between education and employment issues. In her employment practice, Amy represents clients in unemployment hearings, discrimination cases, and wage theft cases. Amy has a BA from Boston College and a JD from the University of Connecticut School of Law. She has been a member of the bar since 2007. I will now like to hand this over to Amy.
Thank you. Good afternoon. We're going to spend some time today talking about disclosing a disability to your employer. If you need to do that, when you should do that, what that might look like, and how to go about doing that. We're going to talk a little bit about the legal landscape. There are, as I'm sure you're aware, some federal laws in place that protect persons with disabilities. First and foremost, the Americans with Disabilities Act. The Rehabilitation Act of 1973, which sort of dovetails with the Americans with Disabilities Act. So we're primarily going to talk about the ADA today. And there are also, because we live in Connecticut, we have some pretty good state protections as well. The Connecticut Fair Employment Practices Act, or CFEPA, as we sometimes refer to it, also precludes discrimination in the employment context. So we'll take a look at that and talk a little bit about the differences under those laws. The purpose of the ADA is to prohibit discrimination. The goal with the passage of the law was to require equal employment opportunities. And as Monica mentioned, reasonable accommodations are part of that, to allow persons with disabilities to do jobs that they are qualified to do with the right accommodations. And you'll see the note here that the Rehabilitation Act also prohibits discrimination in programs that receive federal funding. So again, those two laws are very similar and work very closely together. If you have any questions about that, I'm happy to answer it, but we're going to talk about the ADA. The Americans with Disabilities Act was amended in 2008. So now we have the ADAAA. It was effective January 1st, 2009, and Congress passed it because the Supreme Court had been ruling on these cases in such a way that it really narrowed the protection under the ADA, and it was very difficult to get a judgment in your favor and to prove that you were a disabled person that had been discriminated against. And Congress said that's really not what we intended when we passed the Americans with Disabilities Act. So they passed the Amendments Act, and they said you really need to construe these provisions in favor of broad coverage. It shouldn't be a difficult question to figure out whether or not someone is protected under the Americans with Disabilities Act. And one of the regulations that I've cited to here says it should easily be concluded that the following types of impairments will, at a minimum, substantially limit the major life activities indicated. And it does specifically list epilepsy there. So again, by passing that, Congress was saying this should not be, a very stringent test. You should really find people eligible. So we're going to talk about what the Americans with Disability Act says, and this is how it defines disability. It's a physical or mental impairment that substantially limits one or more major life activities. It could also be a record of having such an impairment if you have a history of a disability, or being regarded as having such an impairment. So if you're at a job and your coworker thinks, you have a certain disability, and they share that with your employer, even if you don't really have that disability, they've sort of regarded you as having it, and they may have treated you accordingly. So that's just something to keep in mind. The major life activities, it really, again, it's pretty broad. Generally, activities like caring for oneself, seeing, hearing, eating, sleeping, walking, speaking, communicating, could be learning, anything you can generally think of that would be a major life activity. Bodily functions, neurological, brain, endocrine systems. And then it does talk about here an impairment that is episodic or in remission is a disability if it would substantially limit a major life activity when active. So if you have a diagnosis of epilepsy or a seizure disorder, even if you haven't had a seizure in decades and it's well controlled, that doesn't mean that you're not protected under the Americans with Disabilities Act. This says that because when it's active, it would substantially limit a major life activity. Under the ADA, it covers employers with 15 or more employees. So that's one of the first, when we have a client come in, we will ask them, how many coworkers do you have? Because it's important to know that for coverage under the ADA. It does cover both public and private employers, and includes state and local employers. And then again, the federal government and programs receiving federal funds are covered by the Rehabilitation Act. So it's pretty broad. It's really, the only limitation there is regard to size of the employer. But again, because we live in Connecticut, we're going to take a look at our state law that provides a little more help in that regard. Employees, anyone who works for a covered employer, and there is language in the Americans with Disability Act that talks about being a qualified individual within the meaning of the statute. So that means you're able to perform the essential functions of the job. That's that last bullet point. Even if you need reasonable accommodations to do so, you are protected. Under Connecticut, as I mentioned before, we have the Connecticut Fair Employment Practices Act, or CFEPA. And this applies to employers of 3 or more persons. So if we're talking about a smaller employer, if you have 5 coworkers, the ADA may not necessarily help, but state law does and provides much of the same protections that the ADA does. And it goes a step further here. The definition of physically disabled under CFEPA talks about, you can read it there, but it does specifically, explicitly list epilepsy as being covered as a physical disability. So we have that protection under Connecticut state law, which is very helpful, especially when dealing with smaller employers. And the CFEPA is, I sort of highlighted this here. This is, I think, the main provision, but there are a lot of different provisions that can help in various ways. But an employer, except in the case of a bona fide occupational qualification, cannot refuse to hire or employ, and they can't discharge from employment an individual or discriminate against them because of their physical disability. So again, very, very comparable to the ADA. It's mission, the goal of this law is to prevent discrimination based on physical disability. And I put in this slide here. It has some very good protections for pregnant workers. And my thought was, if you are dealing with epilepsy or a seizure disorder that has been very well controlled for a long time, but you become pregnant and start having some complications because of that epilepsy or seizure disorder, there are a lot of very good protections for pregnant workers in CFEPA. And the one I put here, your employer can't refuse to grant you a reasonable leave of absence for your disability resulting from a pregnancy. So if that becomes an issue, just know that there are protections in that regard as well. The Americans with Disability Act doesn't require job applicants to disclose that you have a disability. There's nothing in the law that says you have to tell an employer up front. Employers can't demand that you disclose up front. That's illegal. But you may want to disclose if you need a reasonable accommodation for the application process. if you're interviewing and, your the seizure disorder that you live with, requires you to not be in a room with fluorescent lighting, for example, you could ask them for an accommodation in that regard, and they should be able to accommodate that. Just because you're not disclosing up front if you have a seizure disorder, you still have the ability, once you become an employee, to go to your employer and disclose that and ask for needed reasonable accommodations. Just because you're not disclosing it up front doesn't mean you're foreclosing yourself from ever disclosing it, because there are protections that come along with disclosing it. So we're going to talk a little bit about the various stages in the employment process. When you're just applying for a job and, before you've gotten a job offer, an employer is not allowed to conduct a pre-employment medical examination. They can't ask that up front. They can't ask if you have a disability, and they can't ask about the nature or severity of your disability. The law prevents them from doing that. They can't ask if you're able to perform job-related functions. So, for example, again, they can't ask whether you have epilepsy or a seizure disorder. They can't ask if you take any prescription drugs, or if you've ever had to file for workers' compensation or been injured on a job. But they can ask questions, whether or not you have a driver's license, or whether or not you're able to operate heavy machinery, because those would be directly related to the functions of the job. Before you get an offer, if you voluntarily disclose that you have epilepsy or a seizure disorder, what can the employer ask you? They're really generally not allowed to ask follow-up questions at this phase, but they can only ask you questions if the voluntary disclosure has made them reasonably believe that you would require an accommodation to perform the job. So they might, if you disclose to them up front, they might say, okay, well, what kind of reasonable accommodations do you think you would need? And they are allowed to ask about that, but they're not generally able to ask all sorts of questions about your epilepsy or seizure disorder at that point in the process. So I have this example here. So if you're applying to be an administrative assistant, and, one of the things they want you to do is pick up food and set up for various meetings in the office. And if you don't have a driver's license due to your seizure disorder, the picking up the food, driving there is not an essential function of the job. Just being able to get the food and doing the setup is the essential function. And because there are other ways to get there, you could have a coworker drive you, you could take public transportation. You wouldn't really need an accommodation to do that function of the job. So the employer shouldn't really ask any follow-up questions, because there are multiple ways to perform that function. Okay, so now the employer has made you has extended a job offer. What can they ask you at this point? They can require a medical examination to a job. They can require that job applicants have a medical examination, but all employees must be subject to the same examination. So you can't just subject those individuals you suspect of having a disability to the examination. The results can only be used for valid employment purposes as outlined by the ADAAA, meaning you can't use them for discriminatory reasons, and they have to be kept as a separate confidential medical record. And we can talk more about this, and if folks have questions, I can talk about it. But whatever you're revealing to the employer should not be shared with coworkers. It really is on a need-to-know basis, depending on whether or not you need accommodations and who would need to know about those accommodations in order to implement them. So if there is a medical examination, it should be kept confidential, and if not, then that's an issue. So after they've made you a job offer, but before you start the job, they are allowed to ask some follow-up questions. Whether you've held the same job since you've been diagnosed, or a similar type of job, whether or not you take any medication, whether, if you still suffer from seizures, and if so, what type, how long it takes you to recover after a seizure, and whether you need assistance if you have a seizure at work. So again, that's, if you have disclosed to them that you have epilepsy or a seizure disorder, they are allowed at that point to ask these follow-up questions. And they can ask for medical documentation from your doctor, just saying that, yes, you can safely perform the essential functions of the job that you've been selected for. And we'll definitely talk more about that when we talk about reasonable accommodations. Can an employer withdraw an employment offer based on disclosure of a disability? Generally, no. Only if they determine that you're just an applicant's epilepsy or seizure disorder poses a direct threat in the workplace. And this is sort of objective. And one of the examples that was given in the guidance is a welder who's working with very hot equipment. If that person may have seizures while on the job, that could definitely pose a direct threat to their health or safety because of the kind of machinery they're using. And some factors that they consider are the duration of the risk, the nature and severity of the potential harm, the likelihood that the potential harm will occur, and the imminence of potential harm. It can't be a sort of a hypothetical, remote kind of harm. It needs to sort of be real and immediate. And I would say that if a person with epilepsy or a seizure disorder has, is taking medication and has not had a seizure in decades and feels that their condition is well controlled, then I think arguably they wouldn't be a direct threat. And we'll talk, I think, next time more about some case law on that. So when you're hired, we talked a little bit before about qualified individuals. That means that you need to be able to perform all the essential functions of the job. It doesn't include all the marginal functions of a job. So for example, if you're an accountant and you're able to do all your accounting functions, and maybe if you can't drive, that's drive to a meeting, or there are ways around that, and that's not, driving places is not an essential function of that job. They look at there's several things they look at when talking about whether or not it's an essential function. It could be the reason why the position exists. So for example, if you're applying to be a bus driver, you need a driver's license because that driving is an essential function of that job. That's why that job exists. The function may be essential because of the limited number of employees available who can do that job. If you have a small employer and you're hired to do something in the office that nobody else does, so there's only one person there, you really need to be able to do all, that essential function because nobody else can do it. Or if you're hired for your expertise or ability to perform that particular function, that would also make it an essential function of that job. And so when we're talking about, there's a lot of argument in the case law, and a lot of cases we'll look at, well, how do we know this is an essential function? Maybe it's not an essential function. It really comes down a lot to whether the employer thinks it's an essential function. So it's their judgment. They're going to write up a job description and say, we're looking for somebody to do X, Y, and Z. And, so when we get to cases and people filing complaints, they're going to go back and look at that job description and say, we needed somebody to do this. the amount of time on the job performing the function. You know, again, if it's a marginal piece of what you do that you really don't spend a lot of time doing that, it's probably not an essential function. The consequences if they don't require you to do that. A collective bargaining agreement, if there's one in place, and there aren't collective bargaining agreements in all instances, but certainly that would be, you know, usually includes a job description and what the members of the bargaining unit are expected to do. The work experience of past incumbents on the job or similar jobs. So did they perform that kind of function? So if you need help doing one of the essential functions because of your epilepsy or seizure disorder, you at that point, if you haven't already disclosed to your employer, you can at that point say, okay, well, I need a reasonable accommodation to do this function of the job. And I of course, you know, would encourage, you know, and we can talk more about this if people have questions, but I think it's always probably best to put it in writing when you're looking for a reasonable accommodation. As a lawyer, I love to see the paper trail, and in some of the cases that I've been reading, there's sometimes a question as to whether or not the employee ever informed the employer that they had a disability or needed a reasonable accommodation. So if you put it in writing to them, it makes it much harder for them to deny that they knew. And also, if you need to bring a discrimination claim, I think it's helpful in that regard. But so reasonable accommodations can mean a lot of different things. Modifications or adjustments to a job application process, modifications or adjustments to the work environment, or the manner or circumstances under which the position held or desired is customarily performed, that enable an individual with a disability who is qualified to perform the essential functions of that position. So, you know, sometimes that's, again, I had mentioned before, like fluorescent lighting, if that's a trigger, you know, you can ask for a reasonable accommodation that you have a different kind of lighting in your office or workspace. If you are a person that, you know, tends, if sleep throws you off and can trigger a seizure and you're very tired in the morning, you know, perhaps a flexible work schedule might be a reasonable accommodation, or starting later in the day. You know, if heat can trigger seizures, making sure your work area is at a comfortable temperature, all of those kinds of things, you know, whatever it may be. And of course, it's a very fact-specific inquiry based on your individual needs, could be a reasonable accommodation. Basically, any modification or adjustment that would allow you to enjoy benefits and privileges of your employment as enjoyed by other similarly situated employees without disabilities. So anything you need that's going to allow you to do that job the way a person without a seizure disorder might. We already talked a little bit about this. Making existing facilities readily accessible, job restructuring, part-time modified work schedules, qualified readers or interpreters. Again, anything you might need to help you perform the essential functions of your job. And when you go to an employer and say, I have this disability, I'm asking for a reasonable accommodation, it's their obligation to engage with you in an informal, interactive process to determine the best appropriate, reasonable accommodation for you that's going to allow you to do your job. You know, it's usually not good enough for them to say, nope, we're not, you know, we can't do that. They really need to interact and sort of ask some questions. Again, at this point, they might ask for medical documentation around that. And, you know, there were cases that sort of talked about they don't have to give you the specific accommodation you're requesting if another accommodation would allow you to do the same essential function. So it doesn't necessarily mean you'll get your accommodation of choice so long as they are agreeing to accommodate you in a way that sort of solves the issue and allows you to perform that essential function. The only time they don't have to provide a reasonable accommodation is if they say, it's going to really cause an undue hardship for us as an employer. And really what that means is that it would create significant difficulty or expense for the employer. And, you know, there's a lot of, there's a lot of different situations where that might be and where they would argue that, but especially if you have a smaller employer and, you know, the reasonable accommodation requested can be expensive, or, you know, if it required them to hire another person so that you weren't working alone, and you know, things along those lines, that they could say, you know, this would be too expensive for us. We're not able to accommodate that. But they would have to prove that. So your employer, once they know about your disability, if an employee with epilepsy or a seizure disorder is having some performance issues, they are allowed to ask if they think that the disability might be connected to the performance issues. You know, they can ask some follow-up questions, and they can also ask questions to support the reasonable accommodation request. As I said, they can ask for medical documentation to verify your use of sick leave. And I think that would be, you know, if they require all their employees to verify why they're out sick, that might be the case. Or to enable an employee to participate in a voluntary wellness program. And I think one of the important things, I'm sure people are sometimes hesitant to tell their employer about these things because they fear that they might face discrimination or be treated differently. But you know, my take is sort of, you know, as I said before, you kind of want to put it in writing, because I think that gives you some protection under the Americans with Disabilities Act. This was a case that I have on the screen here. There was a gentleman working for an employer. He suffered a seizure at work, and without realizing what he was doing, he had taken off his clothes and put them on the table. The employer didn't know, though, that he had a seizure disorder. He never told them, never gave them any medical documentation. So they made the decision to terminate him. And it wasn't until after they had already, you know, had their meeting and said amongst themselves, right, we're going to terminate him, that the employee then said, well, this happened because I had a seizure disorder and I was suffering a seizure at that point in time. And so what this case, and this is a Fourth Circuit case, so, you know, we're in the Second Circuit, but I thought it was an interesting case. The court said that in a request for an accommodation made after the misconduct is insufficient to sustain a failure to accommodate. So essentially, you know, and there's plenty of other case law that talks about if you haven't informed your employer, then you can't say that they've terminated you for a reason related to your disability. So again, as an attorney, I think it's helpful to disclose and helpful to engage in those interactive conversations with the employer, just so that if you ever have to come back and say, you know, I think I was terminated because of my seizure disorder, you know, you have a lot of good evidence behind that. And then finally, again, as I mentioned, I'm sure sometimes individuals don't want to tell their employer, but another thing to be aware of is that the Americans with Disabilities Act specifically prohibits retaliation. So if you've engaged in advocacy under the ADAAA, if you've asked for reasonable accommodations, you know, your employer can't retaliate against you. They can't coerce, intimidate, threaten, or interfere with your in the exercise or enjoyment of your employment. So that is something else to keep in mind, and that's sort of a separate claim. You know, it's a type of discrimination claim, but for folks who are sort of afraid to come forward, it doesn't necessarily mean that your employer is never going to do something they shouldn't, because of course that's why I have a job. But there is that added protection that employers are expected to not retaliate against persons with disabilities who are just trying to get the necessary reasonable accommodations. Okay, how is that, Monica? Are we ready for questions?
Yes. So if people have questions, if you can type them in the bottom of the screen in the little chat bubble there, we'll go ahead and get those answered for you. So we'll give you a few minutes to type. I know I had a few questions, I guess, to start with, Amy. One of them, referring to one of the points that you just made. So you mentioned that if an employee does not disclose that they have a seizure disorder, and then they have a seizure at work, the employer would not be held accountable for firing them, or like that wouldn't be considered discrimination? Was I understanding that correctly?
Well, I think it's slightly more nuanced. So, you know, I would think that if they fired you just for having a seizure, I think you might have. I mean, I think arguably that's a claim right there. I think in the situation in that case, it was because he engaged in conduct while he was sort of not. In the midst of a seizure, so he may not have had full control over what he was doing, and took off his clothes and sort of stood in the middle of his office. So they sort of characterized that as misconduct. And, you know, I think if I remember the facts of that case, he may have had a history of kind of similar misconduct or other kind of job-related things. So they, you know, that happened and they said, okay, we're going to terminate you. And he then said, well, wait a minute, you can't terminate me because this happened because I was having a seizure at that time. But he had never told them or gone to them and asked for a reasonable accommodation or provided any medical documentation. So, you know, I think if it was something like, you know, if you're sitting at your desk or if you're in a meeting and you have a petit mal seizure, and, you know, you're sort of out of it for the next half an hour, I would like to think your employer wouldn't terminate you just because of that if there was no other sort of related misconduct. You know, and at that point I would think a good employer would probably ask some questions, and, you know, I think it would be in your best interest at that point to disclose, especially if, you know, if there is no discipline on the table, you know, you know, you might want to disclose, and there's other good reasons to disclose too. You know, if you need help, you know, you want the folks around you to sort of know what to do. If you're prone to grand mal seizures, you want them to know to call, who to call, what to do, what not to do. So if you need support in that, you know, in that regard, I think it's helpful to disclose as well. Did that sort of answer the question? Does that make more sense?
Yeah, it did. And I think that is like a good point. And because there are so many different types of seizures in epilepsy, that an employer is not going to be able to recognize the symptoms, which can include disrobing. So for some type of epilepsy, that's like a common behavior.
Yeah.
That it, like you said, is not something that they control or even know that that's what they're doing. But the employer wouldn't know that if they didn't ahead of time.
Right.
You know, we're not informed that was the case. So, okay. Well, we do have one question here that is asking if someone has a seizure and then tells the employer that he has epilepsy, then the employer requires a doctor's note. An employee returns to work and then is fired a week later. Does that meet the requirement of notification, or is an example of failure to disclose?
Yeah, I absolutely think that does meet the requirement for notification. You know, and in fact, if you've gone so far as to provide medical documentation, I think there's really absolutely no way that employer can deny that they know you have a seizure disorder. And so then, yeah, I've had cases like that where a client will get a letter from their doctor saying, you know, I have a seizure disorder, but it's very well controlled, and, you know, here are the couple things that trigger it, but you know, otherwise this person is on medication and should be able to perform all the essential functions of the job. And then the employer turns around and say, well, you know, we disagree, we're going to terminate you. I think that gives rise to a potential claim for discrimination. So yeah, I think you've met your your notification requirements. It's really, it doesn't have to be extensive. But again, the cases I've seen are where, somebody told maybe a supervisor and, but not the boss, or they told a coworker. And so then the court kind of gets into, well, who knew, when did they know, who knew what? So that's just kind of why I say it's best to put it in writing, figure out who you need to talk to. But once you've told, somebody in a management position, again, they have that obligation to sort of engage in that interactive process, and they need to follow up with you and talk to you and figure out, okay, how can we, what are your needs, and how can we reasonably accommodate them so that you can do their job, you do your job.
Okay. Thank you.
Yes.
And for I was just interested about the CFEPA that you mentioned. I don't think that was something that I was aware of. And so that covers people that maybe are working for a smaller employer?
Right. Their limit is 3 or more, and the ADAAA was 15 or more. So if you have a smaller employer, it doesn't mean you are, precluded from filing a claim. It would just be under state law.
Okay. And is that something that they would file through, or file separately?
The process for filing would still be the same. You would file with the Commission on Human Rights and Opportunities. That's our local Connecticut office that handles those types of discrimination complaints. And so the complaint might look, identical to what you'd file under the ADAAA. You're just going to kind of check off a different box for what law you're filing under, basically.
Oh, okay. I'll have to share that information with our clients, because I don't know if that's something that you see very much out there.
Yeah. We're fortunate to be in a state that has some better, federal law allows states to have better protections, and Connecticut in this case does, which is nice.
Yeah, really. And is there a limit to the amount of reasonable accommodations somebody asks for?
No, some people only need one, some people need multiple accommodations. And really, again, as long as the employer's always, they can come back and say, well, that's going to create an undue hardship because, we're a small employer and we can't afford, whatever accommodation you're looking for, or, all these multiple accommodations, we're not able to do that. But generally, it's all very fact specific and depends on what you need, but there's not a limit, like you're only allowed to have one accommodation or 2 accommodations. That shouldn't be an issue.
And what would your suggestions be to somebody, and I don't know that this would happen very often, but for someone that's going through the application process and the employer is requesting a medical examination ahead of time, or they're asking questions related to their medical history all during the application process, what would be your, how should an applicant respond to that?
I think they're not required to give that information, and certainly they have a potential discrimination claim there, and they can contact an attorney or file a complaint with the CHRO. Unfortunately, it's very difficult when you're a job applicant, because what you really want is the job, right? You're applying for a job, you want to get the job, you want, and so when it gets to that part of it, I suppose as an outcome you could seek to be given the job. But yeah, you don't, that's illegal. They shouldn't be doing that. If they are doing that, I think you're able to file a claim under the ADAAA.
Or like the applicant could actually say, you know, I understand that my rights are that I don't need to disclose this information at that point. Would you even suggest that, you know, that somebody like verbally confront the employer at that time?
I don't know if I would say, yeah, I mean, I'm going to give the lawyerly answer and say it depends. I mean, I think it's probably good to have it in writing. You know, if they're asking that right on the job application, I think you could decide not to answer or say, you know, I'm not going to provide that information at this time. You know, and certainly if they're demanding that you go for a medical examination before they've even offered you a job or asked you, you know, do you have a disability and what kind of disability do you have? I mean, it looks like they're screening out people with disabilities. And so the reason why I say, you know, do you want to, you know, confront them? I think if you felt safe doing that, but also you don't always know why they're asking and what, you know, who they are. So, you know, I would be cautious there, but I think you could choose not to answer. And then, you know, if you're otherwise qualified and, you know, you have a resume that says you can do that job and you're not selected, I think you absolutely, you know, have a potential claim of discrimination there.
Okay. And one question here is asking, how would you define heavy equipment? If a doctor in their documentation that's being sent to an employer saying that the employee cannot operate heavy machinery or equipment, what would be a definition of heavy equipment? And the employer, I guess, used that as a reason for them being fired. So
Okay.
there's basically the employer saying that the machines on one of the floors that they were qualified to use, you know, they couldn't, the doctor basically is saying that they couldn't operate. So I don't know, how would you like define heavy equipment, or should the doctor have been more specific? I don't know.
Yeah, I don't know that. I would have to go back and look and see. I don't think that's defined in the ADA, but I think certainly if you're looking for an accommodation with your job and you know what the equipment is, you know, you might want to have a conversation with your doctor and say, here's what the machine is, and here's what it does, and here's what I need to do to use it. And then, you know, I would, if possible, you want to have your doctor be specific, and say, yes, you know, this person's seizure disorder is very well controlled. They haven't had a seizure in 5 years. You know, I don't, they have no restrictions and should be able to use this machinery. So if I understand correctly, in the case you're asking about, though, the doctor said the person was not safe to use heavy machinery, and then the employer sort of interpreted that as, well, they can't use the machinery here.
Right.
Okay.
Yeah. So they don't, I don't know if they just assumed that it was any machine. I don't know what kind of machine it was.
Yeah.
Right.
Yeah. I mean, if that's an essential function of the job is to use whatever machine, and the employer kind of characterizes it as heavy machinery, that could be problematic. And, you know, I've sort of seen that in cases where, you know, doctors are very well intentioned, but they're busy. And so they don't always take the time to sit down and understand, okay, what kind of reasonable accommodation you need, and what do you need me to say? Not that you're dictating to the doctor what it is, but, you know, to kind of understand what the concerns are around that and have the doctor write, you know, a very precise note. That I have seen cases where that becomes problematic, and then you're fighting in court about, you know, what does the doctor's note mean? And I think, you know, I have seen cases, though, where the employer, you know, if you sign a release for the employer to speak to the doctor, the employer can then go back to the doctor and say, okay, we got this letter. and you say no heavy machinery, would you consider this to be heavy? They can, I would argue that's part of the interactive process, and that best policy would say the employer should do that. But definitely I've seen situations where what the doctor writes can become very problematic for the employee.
Mm. And my apologies. So it really was heavy equipment was what the doctor said. I don't know if that's the same thing, heavy equipment, heavy machinery.
Yeah, I don't know that there's one definition of it. I think you just have to sort of look at, we talked about that direct threat, and, there was a case about the welder, right? A person using welding equipment. So I think it would depend on what the machinery did and what the person using it had to do. And, if you had a seizure while using it, could that really cause significant harm to you or someone else? So yeah, I don't think the heavy machinery, and I could go back and look, but I haven't seen a definition specifically for that. But I think you just want to inform your doctor as much as possible, like, hey, this is what I do for a job. Here's the accommodation I've requested. And try to make sure the note is as informed as possible. And then if your employer has questions, encourage them to have a follow-up conversation with the doctor.
Yeah, I think that's a really good point, the patient needs to be clear with the doctor too. Like, this is what I'm doing. This is the kind of piece of equipment I'm operating.
Yeah.
Is this okay? Or, to really have that open communication just there with the doctor, so that they, because this person is right. Like, that's pretty vague though to send to an employer.
Yeah.
What does that mean?
Yeah. And, and it's hard too, because I can certainly understand that people don't want their employer, like, just having carte blanche to talk to their doctor. But the employer they shouldn't be able to access your entire medical history or your medical records. It should really be pretty narrowly focused on, your job functions, and are you able to perform your job functions? And if not, what accommodations might you need?
Right. Yeah. And unfortunately, it just seems like in so many of these cases with our clients that the employer just doesn't, they don't want to accommodate. They don't want to really engage this whole situation of dealing with someone that could potentially have seizures on the job. So instead, they just terminate, and then most people don't, they just let it go. So that's part of the reason why we wanted to have this presentation today, because I think it's just a difficult situation all around, obviously. You understand that. So one more question here is asking, how do you disclose your disability to an employee?
To an employee, to like a coworker?
Yeah, I guess if someone thought it was appropriate or necessary, or I don't know if they're asking, should they disclose to an employee? Or if they do, what should they say?
I think they can say whatever they're comfortable with, but just, keep in mind that disclosing to a coworker is not necessarily going to be imputed to the employer. So if I tell, the attorney who works in the office next door to me, something about a disability I may have because he and I are friendly, that doesn't mean that the employer knows that I have that disability. So, I think, when you're talking about coworkers, I think it's fine to disclose whatever you're comfortable with disclosing based on your relationship with them. But to disclose to your employer, I think you could, again, there's no one right way to do it. I think it's good. I think it's best practice to kind of put it in writing, just so that if they ever came back and say, oh, we had no idea, you never told us, there it is in an email. I think you could just simply say, I have a medical diagnosis of a seizure disorder. I'd really like to talk to you about having a more flexible schedule as a reasonable accommodation based on my seizure disorder. You know, it can really be as simple as that. And again, once you put them on notice, it's up to them, up to the employer to engage in that interactive process. They can't just, you know, not ask any questions and be like, nope, you know, we're not going to accommodate you. They really sort of have to follow up. If they require medical documentation, they can ask for medical documentation as to why you might need a flexible schedule, or, you know, how your seizure disorder impacts you in a way that you would need a flexible schedule. So there's not necessarily any magic to it, as long as you are telling somebody that's high enough up the employer management chain that, you know, knows who to report. You know, if it's a bigger corporation, it's, you know, you might have an HR department, and they deal with this stuff all the time, and they have reasonable accommodation request forms, and they're going to send that right to you and say, okay, here's the form you need to fill out. You know, if it's a very small employer where, you know, it's you and 4 other employees, it's probably the owner or the president or whoever's running that office would be the person you'd need to talk to. And you can, you know, you can have a conversation with them. Again, I think writing is best, but, you know, you just want to be able to show that you did inform them. And hopefully that will result in them, you know, doing what they should do and figuring out the reasonable accommodation issue. And as an attorney, I know that certainly is not always what happens, but if it doesn't, you know, there is legal recourse, as we've been discussing. If you have questions, you're welcome to contact me. If you have questions about specific cases or employment issues that you've witnessed, or, you know, you're welcome to contact us here.
Great. And should they just dial the, is there like a main number over there?
We do have there it is.
Yeah.
860-541-5000. That's our main number. That'll put you through to the front desk, and then, you know, just tell them you have a potential employment discrimination issue, or if you have questions, and, you know, then we would do an intake. We do have income limits for our services, but that, you know, it also depends a little bit on where you live and how old you are. But yeah, so I would encourage, you know, if anyone has a question, or you know, if you have a more general question, you can email me. My email is there. Yeah, you know, that would be totally fine.
Great. And I know we're really running out of time here, Amy. We just have one more question. Is that okay?
Yeah, absolutely.
Okay. So this question is saying that this person in their job disclosed their disability, and then the first mistake they made, they were fired. Is this discrimination?
That depends. You know, I think probably need to talk to that person, because it, you know, you know, when you start a job, an employer is usually going to give you a handbook or the policies that they go by. You know, and some places will have progressive discipline, and some places don't, you know, so some, you know, sometimes they can fire you for, you know, any offense, even if it's your first offense. And if it's a serious mistake, then, you know, I don't know that it was necessarily discrimination. So basically how a discrimination claim works is you allege discrimination, and then the employer gets to sort of rebut that. They, you know, they can say, no, I fired them for making this mistake, this serious mistake that cost us, you know, a customer or X amount of dollars, or, you know, they got in a fight with their coworker or whatever. That's why we really fired them. But I guess I would say, if you think that it, you know, it's absolutely possible that it's related to the disability, you know, I wouldn't discount that, but you would certainly, you know, I would need to talk a lot more with that person and kind of get some more details there. But it's possible it's discrimination. You know, and it's certainly one of the other things they might look at is the nexus in time. If you disclose your disability and you work there for 6 months without issue, and then you make a mistake and they fire you, maybe that's not discrimination because you've worked there fine for 6 months. You know what I mean? So there's a lot of factors
Right.
to consider, and I'd want to ask a lot more questions, but it's possible it's discrimination.
Right. Thank you. And for those listening, we are hoping to do a second part to this here series where we're going to be discussing in more detail about what to do if you are terminated from a position. So stay tuned for dates and upcoming dates for that webinar. Well, I'd like to thank Amy Dion for her time and expertise in this area. Very important information, and I hope everybody on found this helpful. This has been recorded and will be available on our website probably at some point next week. And our website is epilepsyct.com. So thank you, everyone. I hope everyone enjoys the rest of their week and weekend. Thank you.
Thanks so much. Take care.